Welcome everyone. My name is Anil Changaroth. I'm the co-head of the ESG practice at RHTLaw Asia, right? And this is our first in a series that we are doing across the next 5 weeks. It's a mid-year term review of the construction industry and case law, right? And how this is going to be conducted is very simple. Today's event is from Singapore, so both Shafiq and I will be dealing with 2 cases, right? And on certain topics in the construction industry in the last 6 months. And then we will, after we do this for about 20 minutes to 25 minutes, we will then have Korea, followed by Indonesia, followed by Vietnam, followed by Cambodia, sharing in 5 minutes their views on that topic, the particular topic of the case that we are addressing, right? And then we'll open for Q&A, all right? So if we can then start off, I will start with just introducing all the speakers that we have from the region here. And we'll start with Korea. Could you introduce yourself and just quickly tell us the background as well? Jason.
Yeah. My introduction here. My name is Jason Park. In Korean name Jason Park, and I represent the Korean countryside here. And I work and I'm with DR and AJU. We are a member of this ASEAN Plus group that we have here, and I do have about 13 years of practice construction experience. Most of my career was with working in-house for a major corporations, construction companies in Korea. And I moved to this firm, law firm, about 2 years ago, and I'm currently supporting our construction group in our firm.
Thank you. And then next we go to Adi in Indonesia. Firm background as well, please.
Hi. Thank you, Anil. Hi, everyone. So just a brief introduction. I'm from GHP. I'm a partner at GHP Law from Indonesia. I'm the head of construction practice group at the GHP. So we've been doing I've been doing construction matters related matters, both contentious or non-contentious, for around 10 years. And yeah, here at GHP, we are a full service firm. So we do both contentious with construction dispute as well as non-contentious construction matters, such as preparation of contracts and negotiations and advisory matters as well. It's really nice to meet you all. Back to you, Anil.
Thank you. Next, we have Hung from Vietnam.
Hello, everyone. My name is Hung. I'm a senior associate at RHTLaw Vietnam. We provide full service, including advice and litigation service to our customers in Vietnam. We also do some construction dispute in the past. Thank you.
Thank you. And then we go to Vinak from Cambodia.
Hi, good afternoon, everyone. My name is Wanak. I'm here today with my associate, Mr. Visal. So I'm the managing partner of RHTLaw Cambodia. We are a full service law firm, but myself, I'm more like a general surgeon. I'm specialized in corporate investment, real estate, and construction infrastructure. I also do some litigations, and we are part of RHTLaw Asia LLP in Singapore, and also a member of the APG. Very nice to meet all of you, and hope we can have a very insightful webinar today. Thank you.
Thank you, Anna. And last, I'm just going to ask Shafiq, my senior associate. The reason for that is because Shafiq and I are both doing the presentation for today. Over to you, Shafiq.
Hi, everyone. My name is Shafiq. I've been in practice since 2016, working in Anil. Maybe about 50 to 60% of work are construction-related matters. So yeah, that's about it.
Thank you.
Yeah.
Okay, so now we will just start with the first presentation. Let me just pull this up. So as I mentioned, this is the ASEAN Plus group webinar series, and in this series, it's called the Infrastructure Construction Law Media Review across ASEAN. So today, both Shafiq and I will cover what's happening in Singapore, and then we will have each of our country reps say a few words about their views on those particular cases that we're talking about in Singapore. And next week, we then go into Korea, and the week after we go to Indonesia, the week after we go to Vietnam, and then we end off with Cambodia. Now, just to preface this, while in Singapore we may have case law, it may not be the case in the other jurisdictions, right? The reason for that, so those of you who are familiar with Singapore would realize that we have, what's called Law Watch, and very often the Law Watch provides case law updates very fast and within almost every other day or so. And so therefore we have that. But in some of the other jurisdictions, you may not have that. So today's presentation, we're just going to give you a quick overview of the construction cases from January to August this year. And I will deal with the first case, proactive versus prime, that deals with some back charges, delay in completion and failure to complete. And then I'll hand over to Shafiq, who will do the his next case, and then we'll have the sharing from the countries. Okay. Now, so just a quick overview. In total, there were 6 judgments in Singapore from January to July or close to August, right? And of the 6, this is from January to the 4th of August, but it does not include cases under the Building and Construction Industry Security of Payment Act. Those cases are adjudication cases. They come under the statutory regime of adjudication in Singapore. And so those cases we're not dealing with here. And we also do not deal with the cases that are procedural issues. So for example, one party has taken out an application to set aside a judgment that was made in default or something like that. We're not dealing with that, right? So of the 6 cases, we will just quickly sum up. You'll notice that our slides are also hyperlinked. So what happens is that when you get the PDF version of any of these slides, you can actually hyperlink it, it'll take you to the case, and then you can read about it. So in this first case that was cited 12th of January, it dealt with issues of variation, quantum merit. Now, I'm not sure whether some of you are familiar with the word quantum merit, but quantum merit is sometimes you make a claim on the principle that you have done some work. There may not have been a contractual relationship in written form, but you have been given instructions to carry out work. You carried out those works, and when you're trying to make a claim for it, the other party might come back and say, no, we don't have a contract. But you know that there was a relationship and there was work done, and quantum merit means that you must be paid for some value for the work that you've done. Okay, so this first case had issues of variation in quantum merit. It also had issues of rectification of works and back charges, some of which the back charges issues, particularly a case that we will be dealing with in a short while. The next case, Crescendas Bionics, there were issues about damages, delay in completion, quantum assessment, remoteness, remedies like loss of chance and causation. And then the third case, Capella Asia Pacific, dealt with damages for defect, delay in completion, and contractors' duties for maintenance and defects of liability. So my suggestion to those of you who are going to get copies of our presentation is that if any of these matters catches your attention, you just click on the hyperlink, go in there, take a look, and see what it tells you. Okay. Next, what we had was this Diamond Glass Enterprise case. It talked about variation again. So you notice that the question of variation seems to be a similar topic that keeps coming up. And then liquidated damages. The next case is proactive, which is what we're going to deal with. And the last case is Chiang-Tic realities, which Shafiq is going to deal with. Okay. So now, if we look at the case that I'm dealing with, there were issues of back charges, delays in completions, and failure to complete. Okay, so a little bit of the background. Proactive, the claimant in this matter, sued Prime, the respondent in this matter, for 558,000 Sing dollars, which is a part of their main contract for supplies, fabricate, and install steelworks for part of the construction project. right, pursuant to a letter of appointment that was issued by Prime. Now, Prime happened to be a subcontractor of Positive Engineering Private Limited, which is a subcontractor of the main contractor Shimizu for the development, and the developers were CapitaLand. So this is just to give you a quick background on it. Okay, so this is how the claim was arrived at, and Proactive, the claimant position was this: they were claiming and pleaded that in some time in 2019, it was instructed by Prime that its services were no longer required for roof crown works, right? And consequently, the claimant deducted the portion of 490 over 1,000 from the contract works, right? And it was they called it de-scoping of works. Right now, Prime's the respondent's case was this: they denied that it had instructed Proactive that its services were no longer required. It asserted that in and or around December 2019, it became apparent that Proactive was unable to carry out works relating to the roof crown following multiple delay notice. So here, please take note. Prime is saying, I gave you notice, but you were not able to do the work. And Prime is also saying that the Proactive breached the letter of appointment or acceptance, as it was unable to carry out the installation component of the roof crown works, including the variation works, and there was delay. So the respondent is saying, on the contract itself, you did not carry out the work, and so you are in breach, right? Prime case, as a result of this, right, Prime said that he suffered loss and damages because Shimizu, which is the main contractor, had to then carry out the works and back charge Prime eventually. All right. So back charges is when somebody else has to do the work that you were supposed to do, and they claim it back against you. All right. Now the issues to determine in this case was whether or not the claimant Proactive carry out the contracted works expeditiously. Did they carry out the works expeditiously as required in the contract? And if not, was the delay attributable to them or other factors? You know, very often in construction matters, you realize that if it could be caused by someone else at the time. Now the court decision said this: looking at the evidence, they found that the respondent's work was slow behind. The claimant's work was slow and behind schedule based on the evidence, and the delay was attributable to the claimant not on other factors. The fact was that it was about the claimant's late works. Okay. Now here is an important point to take note. Remember, in a slide earlier on, I said that it looks at the evidence and what was given, and the respondent had said they had repeatedly given the claimant notice. Now the respondent is entitled to back charges because eventually Shimizu had to do the works themselves, and they back charged Prime. All right. Now the question then was whether or not the claimant carried out the works expeditiously. The court noted that the claimant's sole witness consistently disagreed with the respondent's lawyer at trial on all allegations made by the respondents relating to Proactive's delayed contractual works as well as the roof crown works. This is despite the evidence presented by the court by Prime. The critical ones are set out in the next slide. So notice what happens. Here, the respondents are going to be showing in the next slide. I'll show you that they actually repeatedly told the claimants, you're in delay, you're in delay. You need to move this matter a lot faster. And that and some of these points of this, okay, there was an email. Your advice of the following schedule, which we have managed to plead from CapitaLand, defenses or slow progress, and they will exercise their liquidated damages rights. So the respondent is telling the claimant, you're delaying the matter. So you notice that there was things in writing, and that's a very important aspect of this, right? According to the Proactive sole witness at trial, Proactive did not reply to this email, as it chose instead to complete the outstanding works as soon as possible. Now, that is a serious issue. When you are in a construction matter, you must always remember that you need to follow up in writing. If you choose not to follow up in writing, these are the kind of problems you're going to face, right? Now, the respondents had a letter of notification of delay. They issued a letter of notification. You're hereby advised that your performance and so on and so forth was in delay and so on. The current issues at hand concerning your poor performance include first delay, second delay, look at that, third delay. So the respondents are writing, put it all in writing. So this part about putting things down in writing becomes so critical. And you notice that this is what's happening in this particular case, right? Now, the respondents also send out another letter of notification of delay on the 31st of October, right? Again, the claimant didn't reply. And the claimant's excuse and the witness in the testimony was that, no, we just wanted to do the work. How can that be right? Okay. Now, did Proactive carry out the work expeditiously? Again, on the same point, Prime's email to Proactive on the 6th of December, providing a summary of Proactive's manpower with Shimichu's comment. And it says, committed 22 men per day, total workers were observed. So you notice that the respondent is putting down everything in writing. So where is the claimant? Where has the claimant put all of these details down in writing? And it can cause a problem, all right? Prime, there was another email there. There's simply no commitment to want to finish the work. So it states all of these details. Surely the other party must respond to it. Right? Shimichu's email, that's the main contractor as well. Now, further to the email on the 6th of December and our letter of notice of delay to you, dated the 5th of December, we are unable to accept your program to install the ground. In consideration of the delay you have caused us due to your poor performance and shortage of manpower, and on the first few stories, we have decided to engage a third party. So Shimichu is giving Prime notice that they are going to get it done. So obviously Prime will realize that they may be charged back charges for someone else doing the job that they were supposed to do with the assistance of the claimant Proactive. Okay. Notwithstanding Proactive's repeated denials, the court took the view that there was very little doubt that Proactive's work was slow and behind schedule based on the evidence. So all they did was look at the evidence, and the evidence shows that. The court did not accept Proactive's explanation that he did not see a need to reply. Again, so court is telling you that it's very important that you put down in writing all of these things. Was the delay attributable to Proactive or other factors? Because in construction matters, there may be many parties involved, and so sometimes the other parties may have caused it. Proactive's attempt to latch on to Prime's email of the 6th of December, in particular the words, has particularly got their act together and all that. Well, the court says, sorry, this is not going to work because it's not clear. However, the court could not see how any delay of this party, Yabo's part, assisted Proactive or, excuse them for not having done the work within the time frame. So the court is saying you coming up with an excuse of somebody else's doing something else and causing that doesn't work in this situation. Okay, there was this. They looked at particular clauses in the letters of appointment, and there clearly it says who reserves the right to set off and all those kind of things. So this point is very important that you realize that every time that you have a construction project, it is important that you always fall back and look at the contract and what the contract provides. And if this contract have got strict provisions, you need to comply with it. And you need to put it down in writing. If you have any issues with these particular clauses, you must highlight them right at the start. And you can't say, I'm best there to get the work done, and I'm not interested in anything else. Okay. So there was also this appendix C, the subcontractor is liable for and shall fully indemnify, save harmless to the company against and from any breach and so on. So these are all standard provisions in the contract. It's very clear. Every time you have an issue, you must fall back on the contract and take a look and see what happens, right? So the question was whether or not Prime was entitled to impose back charges. Proactive argued that there was no evidence before the court of any back charges by Shimizu. What was before the court was contra charges from Shimizu to Positive, where Prime and Kong Hee, which were named as the parties on behalf of Positive, had charged by Shimizu. That means Shimizu has used Kong Hee, Hui, and there were back charges involved. So therein again lies the fact that these things are on record, right? Prime argued that its claim against Proactive had nothing to do with the issue of privity of contract. It is based on the fact that Proactive was contractually obliged to pay for the installation of the roof works as long as Prime engaged another subcontractor. So if I had to end up using another subcontractor for the works that you're supposed to do, I have to pay that party and there must be offset or set off, all right? The court agreed with Prime and stated the following, very importantly, it is precisely because there was no privity of contract between the main contractor and the subcontractor There's always a contract between the main contractor and the subcontractor, but it doesn't go on this way. It's you and me and the next person, and so on, you know. And so this issue about privity of contract was quite important to highlight. And the court, citing another case, said the back charges is for expenses actually and necessarily reasonably incurred, and that's what happened in this case. The charges is one for which the subcontractor undertook responsibility for that was defaulted upon, because the proactive was responsible for it. They never got it done. The main contractor ended up having someone else deal with it, right? The court was of the view that the prime fulfilled all of those requirements. This part I'll let you all take a look at it on your own. You know, the court is saying actually the respondent has done everything that they are supposed to do as per the contract, and they've put it down in writing and covered those things. Now, the key takeaway then from this case is this. The issue about privity of contract with third-party subcontractors is not necessary for the contractor to be able to impose the relevant back charges on the relevant subcontractors. Those things, if it's provided in the contract, if you were supposed to do this, but you fail to carry out this work, you know that the main contractor or the other party may have to use someone else to do that. And using that someone else, that cost must be borne by you at the end of the day, right? So you cannot use the excuse that, I'm not related to this third party, I've got nothing to do with this third party, and therefore I'm not responsible. The second most critical point is that writing, putting down things in writing are absolutely important. It is, to some extent, I say it's not like rocket science. You just have to understand that these are important to know, right? And this is the takeaway from this particular case, where the claimant actually failed to do what they were supposed to do. They were in delay, and that delay caused the main contractor to end up using a third party, and the cost for that must be borne by this claimant. And that's it. All right, we go down to the next case. What I'm going to do is I'm just going to stop. I'm going to allow Shafiq to then share and carry on his viewpoints on this second case. Thank you so much. Shafiq, over to you.
Yeah, so today I'm going to talk about the case of Chantec Realty and SDK Consortium. So actually this case involves the issue of performance bonds. I think those in the construction industry, especially in Singapore, you'll be familiar with the performance bond, because I think it's quite common in, especially in big construction contracts in Singapore. So actually, essentially, performance bond, just to give a brief background, a performance bond is sort of like a form of security to the employers. So I think back in the old days, employers required contractors to pay a cash deposit to secure the performance. It's only subsequently then the performance bond came into the picture, for which usually for a small fees that you pay to the banks or to the insurers, these financial institutions will then undertake to pay a certain sum of money under certain conditions. Okay, so the most common type of a performance bond is what we call an on-demand bond, where the insurers or the financial institutions will need to pay out upon demand by the employers. And then such performance bonds are generally described as good as cash. But the main issue here is when would the employer be entitled to call on the performance bond? So I think there are quite a number of case law in the common law jurisdiction that talks about calls that are fraudulent. And in the common type of fraud in such situation is where the employer does not have an honest belief that the contractor has defaulted, and therefore the demand must have been fraudulent. Subsequently, there are cases that talks about unconscionability, but then parties now are quite clever in drafting of the contracts, where they try to exclude the issue of unconscionability. That means you cannot rely on unconscionability to stop the call on the performance bond. But in this case that I'm going to talk about today is slightly special, because it doesn't talk about fraudulence, it doesn't talk about fraud or unconscionability. Instead, it talks about the compliance with the conditions of the performance bond itself. So just to give a brief background of the case. So in this case, actually the first respondent is actually SDK Consortium, which was the main contractor of a construction project in Singapore. The party that is actually applying in court is actually Chantec Realty Private Limited, which was a subcontractor of SDK. And of course, the second respondent is the insurance company itself, Lonpac Insurance Berhad. So I think the performance bond under the subcontract, the subcontractor was required to secure a performance bond for the sum of 1.1 million, which was 5% of the total contract sum. Then, of course, in 2020, there were various disputes that arose between parties. Of course, if there's no dispute, there's no need to call for a performance bond. But so in this case, the disputes were relating to certification of payment claims and also in relation to the performance of the subcontract. This ultimately led to actually Chiantec serving its notice to SDK to terminate the subcontract sometime in November 2020. Then just to give a background fact, so SDK actually made the call on the bond on 29 July 2020. Thereafter, Chiantec actually applied to the Singapore court to seek an injunction. The injunction in this case actually to stop Lonpac from making the payment of 1.1 million to SDK. Because what usually happens in this kind of performance bond is, let's say SDK calls on the performance bond and Lonpac, the insurance company, pays out. That usually the insurance company will then go after the subcontractor to recover the sums. So in this case, it was in Chiantec's interest to actually stop the payment so that they don't need to pay Lonpac for the sums. So the issue that was to be determined by the court was whether the call on the bond by the main contractor SDK was valid. Just to give you the conclusion, what the court decided that the court allowed the injunction. Basically, the insurance company is restrained from making the payment of the 1.1 million to SDK on the basis that the demand was invalid. So now I thought it would be better to give you all the conclusion so that you can understand later when I'm going through the explanation where this is where the court's to explain the court's reasoning and how the court came to its conclusion. So to go through some of the relevant clauses within the performance bond, so I'll be going through 3 clauses mainly. The first clause is this: Lonpac shall unconditionally pay to SDK any sums to a maximum of the $1.1 million upon receiving SDK's written notice of claim for payment made pursuant to clause 4 of this guarantee without any proof of actual default on part of Chiantec and without any need to satisfy any conditions. So clause 1, it applies in situations where generally the main SDK can call on the bond without needing to prove that there was actually actual default. But of course, Chiantec can then try to stop this by saying that there's actually fraud in the sense that SDK did not genuinely believe that there was a default. Okay. So the next clause is clause 3. So this clause talks about the termination and extension of the performance bond itself. So in this case, clause 3 says, Lonpac's liability under this bond shall continue and shall remain in full force and effect from July 2018 to August 2022, provided that the expiry of this bond shall be automatically extended for successive periods of 6 months, unless, that means what this part is trying to say is it will continue to automatically extend for periods of 6 months unless Lonpac gives SDK 90 days written notice prior to the expiry of the liability of its intention not to extend the bond. Okay, and upon receiving such notice, what SDK can do is SDK can make a claim under this bond or direct Lonpac to extend the validity of this bond for a final 6 months. So A is basically Lonpac calling on the bond to sort of like secure the performance bond but in cash form, or for B, basically force the Lonpac to extend it for a final 6 months. Then clause 4 talks about how the call on the performance bond should be made. Essentially, it says it should be made in writing, given to Lonpac at the address as stated in clause 4. So before actually the court went into the facts of the case, the court actually reiterated some of the key principles with regards to calling on the performance bond. Essentially, what they say here is that a demand can be made subject to the fulfillment of various condition precedents and or strict compliance with the stipulated forms. This is what in Singapore is called the doctrine of strict compliance. Essentially, if you don't follow any of the conditions in the contract or don't follow the requirements in the contract, essentially it will be ground for the call on the bond to be restrained. Essentially, the court also said that this doctrine of strict compliance does not undermine the purpose of the on-demand bond, because actually, if you follow the contract strictly, it upholds commercial certainty. Okay, so what happened? So essentially, what happened was on the 28th of April 2022, the insurance company Loanpack actually sent a letter to the SDK, the main contractor, saying that this is their 90 days written notice from the expiry. Basically, they are not going to continue the performance bond, and this was their 90 days notice. However, SDK claimed that it did not receive the 28 April notice because it was sent to their old office. They only became aware of it on 19 July 2022 when Loanpack sent a second letter informing SDK of the same. And it was not disputed that SDK received the 19 July notice. And on 29 July 2022, then SDK sent a letter to Loanpack demanding for payment of the entire bond. Essentially, on 29 July 2022, they made a call on the bond for the $1.1 million. And in that notice where they made the call on the bond, they said it was made pursuant to clause 4 of the bond. Okay, this will be an issue later, as I will be discussing later. So whether the call on the bond was made pursuant to clause 1 or clause 3, here the court actually looked at the performance bond itself, because I think the letter mentions that the call on the bond was made pursuant to clause 4. But I think if you recall, clause 4 was not a ground for making a demand. Clause 4 was just how the demand should be made. Then clause 4 merely sets out how the demand should be made, that means by notice in writing, etc. In fact, the court actually said there are only two bases for you to make the call on the bond, which is pursuant to clause 1 or clause 3. So I think as I explained earlier, clause 1 of the bond provides that the bond is unconditional without any proof of default, except that the claim must be made in forms stipulated in clause 4. And Chantec can only obtain an injunction to restrain the payment if it can prove that the call was fraudulent. But clause 3 was different from clause 1, because clause 3 is regards to the extension of the performance bond. So the court actually looked through the agreement and said that under such written notice, SDK can make a claim under the bond. When the insurance company Loanpack gave the 90 days notice not to extend, SDK can either make a claim under the bond or force a final 6-month extension. Then the court looked through the events that took place. Essentially, what happened was that the court viewed the events that took place. Essentially, what happened was on the 6th of July, SDK sought Loanpack's confirmation by phone call that the bond would be automatically extended pursuant to clause 3. Then Loanpack informed SDK that he already issued his 28 April letter. So actually what happened was this. On the 6th of July, SDK called Loanpack to ask whether the agreement was automatically extended, because I think recall they didn't receive the 28 April letter. That was when Loanpack informed SDK that no, actually we issued you the 28 April letter, right? So there's no more extension. Then SDK informed them that no, we didn't receive the 28 April letter, and then that's when Loanpack emailed SDK a copy of the said letter. That was when SDK realized that the 28 April letter was actually sent to their old address. So cut the long story short, essentially, when the court looked at all the circumstances of the case, they found that actually when SDK realized that Loanpack was no longer taking position, that it was extending the performance bond, it decided to then make a claim on the bond. So based on the circumstances of the case, the court viewed that the call on the bond was pursuant to clause 3 and not clause 1 of the agreement, in that the Loanpack had given notice of non-renewal and SDK elected to make a claim on it. But then the court, however, looked at the notice itself and decided that the notice was for non-extension was actually invalid. Cut the long, because in the interest of time, essentially, the court took the position that since the notice was actually sent to the old address, it was not valid service. Okay, because essentially the agreement does not say does not stipulate the address in which the notice should be sent. So if you look at the word notice, essentially any notice that is to be sent to SDK must be some sense must be able to put SDK on notice that there is this notice of non-extension. So considering that it was sent to the old address, therefore the notice was not valid. Here, as SDK did not receive the 28 April notice, it did not constitute valid notice of launchpad intention not to extend the bond. Therefore, there was no extension of the bond. Therefore, the court actually found that the call on the bond was invalid because SDK made the call on the bond pursuant to clause 3, but actually clause 3, the condition of clause 3 did not exist because there was no valid notice of non-renewal. Therefore, in the circumstance, actually the court considered that the terms of the performance bond were not complied with. Therefore, the call on the bond is not valid, and therefore the court allowed the injunction by restraining the call on the bond. So some key takeaways from this case is the main point is actually if you want to that any call on a performance bond, you need to follow strictly with the terms of the performance bond, including any condition precedents or any stipulated forms. Because if you fail to do so, it would be liable to be restrained, or the court may grant an injunction to prevent the call on the bond. But of course, the position taken by the court is, I believe, is also justified because at least it upholds commercial certainty in the sense that this is what the contract says. You have to follow it strictly, otherwise we won't allow it. Yep. The court did talk about fraud and also the implied terms. I think you can just look through the contract to see, look through the case if you are interested to see what are the court's views on these two issues. But then the main decision by the court was mainly due to the failure to comply with the terms of the performance bond and all the forms that stipulated in the performance bond itself. Yeah, that's about it.
Thank you, Shafiq. So the couple of quick points before we have everyone talk about it. You'll notice that in both of these cases, right, essentially everybody talks about make sure you read the contract properly. Make sure you follow up and put everything down in writing. And even if it's notices, it must be following the terms. And, Shafiq said a very critical point. He says the commercial certainty, right? And then strictly looking at the terms, right? So with that in mind, could we then turn to Jason first, right? To take a look at these two cases. I mean, there were issues about providing delays in construction contracts, when and how back charges may impose, and the strict compliance of the condition precedent and stipulated forms. So just a couple of views from the Korean point of view, if you were to look at this. Yes, Jason.
Hi, while the memories are fresh, maybe can I start with the second case?
Yes.
I want to start with a question. Shafiq, you mentioned the bond call was actually made pursuant to clause. There were actually two clauses, clause 1 and clause 3, and the bond call was deemed the bond call was made pursuant to clause 3.
Yeah.
And the court held the bond call itself was invalid because some of the conditions for clause 3 hasn't been met. I guess that's what the gist of the case. Now, couldn't the applicant make a bond call pursuant to clause 1, or was the bond expired under? I thought he would still be entitled to make a call under clause 1.
That was the part that was not clear, because I think when they made the call on the bond, they said it was pursuant to clause 4, but clause 4 was just about where the notice should be sent to the insurers. So that was the reason why when the court looked at it, it was not clear from the facts of the case whether it was made pursuant to clause 1 or clause 3. Of course, if they have made the bond call pursuant to clause 1, it would have been a valid call, because technically there was no extension yet.
Okay.
But then the courts look at the facts of the case. When they made the call, when they made the call on the bond, the circumstances show that it was made pursuant to clause 3.
Right.
Yeah, I hope that answered your question.
Okay.
And if I could just add, Jason, you're
Yeah.
referring to the fact that the clause 1 of the bond provides that the bond is unconditional without any proof of default
Right.
on the
Right.
part of the
Mhm.
party. So, it's an unconditional bond, as opposed to clause 3 envisaged a situation where Longpec had given 90 days notice and about the notice period.
Right.
And so there
Right.
are these two aspects. Yeah.
Mhm.
Go on, Jason.
Right. But well, basically in Korea, I don't know if there's a specific, it's called specifically a strict compliance doctrine or anything like that. But basically in Korea, one would be applying for a preliminary restraining order, but then the case law says that the court will look at this is a very high standard. They will look at abuse of rights, and it'll um, um, you must show there's an abuse of right, and the beneficiary by abuse of right by the beneficiary making the bond call, and that abuse of right has to be explicit and objectively clear. That's the word that the Supreme Court has actually used in their case, and that's basically a very high standard, and it's not upheld by the court when you make an application on that. That's my take on the second case. As for the first case, Korea is a civil law jurisdiction, but I believe the law is not so much different in Korea. In many of the Korean construction agreements, there are explicit provisions on set-off rights, for example. So I'm pretty sure a contractor would eventually have the right to claim back the back charges on their subcontractor, and all they have to show that they had the right to they have to prove that there's something that the subcontractor has done to cause the harm on the contractor, and for example, the delay or the poor performance by the subcontractor would eventually cause the contractor to suffer liquidated damages, for example, imposed by the employer and so on. And as long as they can prove that, the back charges can be claimed. I understand.
Right, Jason,
Yeah.
would that be it?
Yeah, that's it for me.
Thank you. Very helpful.
Yep,
Because
okay.
on the first one, on the performance bonds, what I liked is the fact that you said the courts are very strict. They look at explicit and objectively. They look at it.
Right.
So what you realize, what the audience would realize is this: the principles are all similar, whether you're in common law jurisdiction or in civil law jurisdiction. The standards are the same. So when you're talking about performance bond, there is a high standard, and consider whether or not there was abuse or not. Because you're calling on a bond. So there's this, in common law, is this question of conscionability, whether it's right for you to make the demand. So the principle that you just highlighted is actually very similar. And on the second, on the first case as well, you started off by saying that it's a civil law jurisdiction. So those of you who are not familiar, the common law system has got English background, and you look at case law, but as a civil law system, you look at the provisions in the contract strictly. So there's very little avenue for you to misinterpret it using case law, which is what common law does. But at the end of the day, the results become the same, because you look at the civil law system, you look strictly at the contract, and if the contract provides A, B, C, D, you must do those. And if you don't do those, trade off, you know that there are consequences for that. So thank you so much for that.
Right.
We go to Adi in Indonesia.
Yeah, fine. Thank you, Anil. So I think maybe I'll make a comment on the first case first on the back charges. So I think similar to Korea and also as you pointed out, and Indonesia as a civil law, we don't the law does not typically we don't have the case law which kind of helps in interpretation of how the contract should be interpreted. So the court are actually in case of dispute, the parties are to rely on the strict interpretation of the law. In some cases, parties can ask the court to make a ex aequo bono decision or a decision based on equity. So it gives the freedom for courts to interpret the contract outside of the strict interpretation of the law, and can make a decision based on what the court thinks is just or equitable. In terms of back charges, we do have, if it is not stated under the contract, we do have a similar concept in our civil code. In our civil code, in case of a breach of contract, then the non-defaulting party can claim for actual costs, losses, and also actual costs and actual loss, and losses which could have been predicted, and losses directly caused by the default. So in case of a back charges, we understand that it's for example, the main contractor has to do the work, and then the main contractor claim the cost that is incurred by the main contractor to the subcontractor, and it does fall under the category of actual losses, as long as they can prove that it is actually the damage has incurred, they have incurred such losses. Because I think from the various collective from the various sources from legal doctrines and legal experts in Indonesia, they classified actual losses to include also any replacement or substitute goods which the creditor must purchase because of a certain default by the defaulting party. For example, if they have to complete the job, they have to appoint another contractor, then due to a default of the defaulting party, then they have to then it falls under the actual loss, and it can be back charged to the but also one thing that we will also need to be mindful of is whether or not there is a limitation of liability under the contract. For example, if the contract has a limitation of liability of up to 10% or 30% of the contract value, then it may be a challenge for the claimant to claim for the back charges exceeding the liability that was limited. As for the second issue on the performance bond, I think this is also an interesting topic, because I think Indonesia has a different court system. The court cannot issue an injunctive relief, unlike in Korea and in Singapore. So what happened usually with performance bond is the issuer are actually put in a very difficult position, and that's why we always recommend the full performance bond either in the form of bank guarantee or surety bond to be really clear, without any doubt that that it is unconditional. Typically, I don't know how it is in common law, but I think based on my understanding is that if you say the bond is on demand and unconditional, based on the common law principle, it's clear that unconditional means that you don't have to prove you don't have actual proof the existence of a default. But in Indonesian law, it's not always immediately clear. So what we always suggest is to have the clear provision, clear paragraph expressly stating that there is no need, that so the notice from the guaranteed party loan is a sufficient notice, and there's no. So yeah, the issuer is also put in a very difficult position, because typically what happened is that the guaranteed party make a notice to claim to call the performance bond, and in the other side, the party who the obligor is threatening the issuing the issuer to if they make if they issue release the fund, then basically the obligor will sue the issuing bank. So and that's happened in a lot of cases. So most of the time we suggest performance bond to be in the form of a bank guarantee, because in Indonesia a bank guarantee is an official bank product which are recognized under the banking law, and failure by the banks to comply with the terms of the bank guarantees may be a reason for regulators to suspend their banking license. So this is also one of the strategy that we use if we represent the claimant. We usually put additional pressure to the issuing bank if they resist, if they're reluctant to immediately release the fund. We also report the failure of them to comply with the bank guarantee to the regulators, to the central bank. So yeah, I think I wouldn't say that the surety bond is not enforceable. It is still enforceable, but it's not as recognized as the bank as a bank guarantees, because bank guarantees is actually recognized as an official bank banking product. I think that's from
thank you, Eddie. I'll just make 1 or 2 points, but I just like to let everybody know that we actually at the 1 hour point. But so with your indulgence, we still have 2 more countries we want to cover. So bear with us as we take you a little longer than the 1 hour mark. Now, Eddie, you started off by saying civil law, right? But you correct me if I'm mistaken. It's a combination of civil law and Dutch law as well, right? Is Dutch law civil law? Or is it slightly different?
Dutch law was civil law. So our law was based on the ancient Dutch law, which was a civil law.
Yes. Okay. So on that, I like the point that you also highlighted. At the end of the day, the court might look at equity, right, to make a interpretation. And there's because it is civil law, there's very little room for you to interpret the contract otherwise than what is stated in the contract. So again, it comes back to the same points that we use on common law, but and the back charges and everything else would be provisions in the contract. So that's a good point. On your point on performance bond as well is really relevant, because in some countries, in some jurisdictions, they don't use a bank guarantee, which is far more secure than other forms of guarantee. So we've had a matter, Shafiq and I had a matter where it was an insurance company's guarantee. And therein lies some complications of timelines and whether they follow or not. And your point about, it must be unconditional to be safe. So the best, your takeaway is the fact that it should be unconditional bank guarantee. You know that it's a secured position. So thank you so much for that. We go to Vietnam.
Hi.
And we have
Yep.
Hung. Yes,
Yep.
please. I'm gonna pin you.
Yeah.
Yes.
Thank you. So in terms of to proving the delays in construction projects, in terms of the practice in Vietnam, you have to submit the party have to submit their supporting document to prove for the delays. Otherwise, the court will pay on the arguments of the party to make their final decision. And for the delay, the cost of Vietnam, they will treat it at penalties or a compensation. So for the compensation, you have to prove that the actual damage and the fault of the breaching party and the causal relationship between the act of the party causing the damage and the actual damage. For the penalties, there's a ceiling in Vietnam which is 8% of the breaching value. So that the party can agree on a certain amount of the penalty, but it will not. The maximum amount will be 8% of the breaching value, and we will further discuss about liquidated damage, which covers compensations and penalties in our presentations on 20 September. So I will discuss further. And in terms of the back charges, actually, under the laws of Vietnam, there is no concept of back charges. So it will depend on the agreement of the party, and the court will based on the agreement of the party to decide how much whether the back charges is accept, and how much the other party to pay, how much the breaching party have to pay for the other party.
Thank you. And on the performance bond,
So for the performance bonds, mostly in Vietnam, the contracts they use bank guarantees instead of performance bond. So we quite familiar with bank guarantees rather than performance bond.
Okay. Juan, thank you so much. You see, those of you right from the start, I told you all that we taking you across the region and see you have common law and you have civil law. And I like your point about the delays, right? Submission of supporting documents. A very critical point. While the case that I cited didn't address it in detail, or may not be not in our slides, the point of the matter is this: if there is going to be a delay and you want an extension of time, you should ask for it. So whereas in the case that whereas the case that I reported on, he never bothered. He just wanted to complete the job, right? And he was in such delay despite the fact that he was reminded repeatedly. So that's a very good point that you've highlighted. An interesting point that you highlighted was this 8% maximum, right? And you said that we will try and take that point in when we come to your presentation. So thank you so much for that. Again, on the bank guarantee, performance bond, it seems standard across the world, right? Or across the region, right? Bankers' guarantees are the best one. Unconditional bonds are perfect and all that. So thank you so much. I hope that the audience is starting to see that the similarity in how the construction industry works across the board, right? So thank you so much. And we go last to Vinat across Cambodia.
Hi, thank you, Anil, and thank you to the other speakers. I think it's good to be the last speaker because you don't have anything else to say. Well, unlike in Singapore, Cambodia is a civil law system, just like in Indonesia and the other jurisdiction here in Korea. So let it be known that there's no public searches available in Cambodia for court document. So court decision are mostly private and confidential for civil proceeding cases. So there's no way we can analyze or how the procedures of each proceeding, especially in construction matters, would be carried out. And so my updates today, my discussion today would be to give a brief review of Cambodian law relating to back charges, delay in construction, and failure to completion, and performance bonds. So I think our civil code did has certain provision which relate to back charges, but there's a certain requirement that the non-defaulting party would need to fulfill. So one of the requirement, I think similar to Singapore, would be written notice. So written notice should be sent out to the defaulting parties, and then there has to be a defect in place to claim the charges. Then there's a certain period set for the defaulting party to fix the defect, and if upon that certain period the defaulting party failed to fix the defect, by then you can claim for back charges. And again, in delay or failure to completion, most remedy under the construction contract would be liquidated damage, which was set by the numbers of days of the delays. So meanwhile, for the performance bonds, it's just like in Indonesia, in Cambodia, for private agreement, the law is silent. There's no requirement for performance bonds, but private party usually set their securities in BG, in bank guarantee, just like in Indonesia and Vietnam. However, there is one regulation which is dated in 1998, a long time ago, that there's a mandatory requirement for performance bonds for a construction contract between private and public sector, which is mostly in BOT, build, operate, transfer. So build, operate, transfer contract would require performance bond to be in place. But however, there's a limitation of what types of construction. So there's a few limitation as well. So only like construction for electricity, power plant, railroad, highway, airports, telecommunication network, waste production, clean water plant, and there's a few more. So if you would like to explore, we can share. Yes, just like the other jurisdiction, terms of performance bonds under private construction contract in Cambodia is quite new. We always use a BG, bank guarantee, for such a contract. Yeah, and I think most of us cover the requirement, how the performance bond is called, and how to claim for the back charges already. So I think similar procedures to Cambodia as well. So without any further ado, I think that should be it for me. But I hope we can raise more issue in the next webinar, and hopefully can share more in mind when with the host.
Rana, thank you so much for that. You know, it's very interesting because I'm not too familiar with how the practice is in Cambodia, right? So I was concerned about, you know, whether these issues would be issues that are not dealt with. But you know, you've kind of summed up for all of us the fact that, you know, you're a civil law system, right? And so it can be different from it. Two, you also said that, you know, there's the certainty of the contract is important, and if you fail to then comply, there's issues about liquidated damages, and the liquidated damages are taken care of and accounted for in the same way as all of us do. So that's a very critical part about understanding that, you know, even in Cambodia, even though it's a civil law system, Vana, you've just told us how it actually applies about the same for all of us, right? Second is when you talked about performance bond, it's also interesting to note that you highlighted the fact that it may not be present in most contracts, except for private contracts, people do demand. And then at the end of the day, when they do demand or they do ask for that, it is in the same principles of unconditional from a bank guarantee. But, you know, BOT, you said, you know, build, operate, and transfer cases are ones where you have examples. So in totality, I think what many of you might see from this interaction that we've had today is that while we in Singapore picked out two cases and talked about certain issues, those issues are also present in the other jurisdictions in slightly, while it may not be in concrete in case law, it may be under the civil law system, it may be within the contract, but the general principles all seem to be the same, right? So I thank you very much, all of the panelists for sharing these views. I noticed that there are no questions in the Q&A box at the moment. There was a message that was just thanking us for it. But I just want to round off by telling everybody that, you know, when we go on to the next week, we're going into Korea next. Now, Korea is going to take a look at either their current cases, which may be different from us, or it could be similar from us. And then we will share all the remaining countries would share our views on that, right? By the time we get to Indonesia, Vietnam, and Cambodia, they may not be case law as Shafiq and I discussed, because that is more common in a common law system, because they always fall back on cases. So please do take note that we may start shifting from pure case law discussions to maybe what is in the legislation, right? So this is what we're going to be doing over the next 5 weeks. But ultimately, we want to showcase to you that one RHT and the group of law firms that we have around the region, all right, have got the the resources to deal with construction matters, and we can also cross-refer matters that we can easily deal with, because we have general principles are all similar. Right. While we have common law system, while we have civil law system, the nitty-gritty details are what these experts who have come on board with us today and will carry on coming on board with us for the next couple of weeks will be able to distinguish and pick out. But collectively, we still have the resources and the foundation for a great working together. So thank you all so much, and thanks for those of you who have joined us.